Hey, other legal warriors. A question I often get is, will I have to talk about my case in court? I'm going to have to talk about my criminal case. I'm afraid to talk. What do I do? Well, if you want the answer to that question, or you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington state for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it and get the help they need. Now I'm just going to jump right into it. For the sake of this discussion, we are talking about criminal cases, not restraining orders or protection orders, criminal cases where someone is accused of a crime. And oftentimes there's a court date coming up and the person accused, our client, a defendant, anybody in that situation, they often are worried about, are they going to have to talk in court, because it's scary. And us attorneys forget sometimes that our clients haven't been through this before, especially if we've been doing it for more than 30 years like I have. So the answer to the question in general is no, you're not going to have to at least talk about the facts of your case in court unless we get to a very special part of the case called a trial where you chose to testify. Otherwise, if you try to talk about the facts of the case in court, your attorney might tackle you or put their hand over your mouth or stop you, because anything you say in the courthouse about your case or anything else can be used against you. And it's taped, right? It's recorded in Washington state, unless it's felonies. It may not be taped. There may be a person transcribing it live with an old machine. But for the most part, they're taped. And so the court doesn't want you talking about the case. We don't want you talking about the case. And the prosecutor, for the most part, will also try to stop you from talking about the case. So what do you mean, Lance? Does that mean that I'm never going to say anything in court? No, that's not what I'm saying. You are going to say something. And typically what you're going to be doing is saying stuff like, yes, I understand, when a prosecutor or a judge asks you a procedural question. The most common thing that happens in a criminal case is a continuance. We have a right to a speedy trial in Washington state. So a judge might ask you, dear Mr. Defendant, do you understand you have a right to a speedy trial within 90 days? Yes, I do. Do you understand that by extending this court date, you're going to waive that for a period of time to this certain date? Yes, I do. Is this what you want to do, defendant? Yes, I do. Great, we're going to go ahead and continue the case. So, your mileage may vary. It may not quite go like that, but that's basically what you're going to be saying in court to the judge or in an open court. Now, you're going to talk to your attorney on the side, and hopefully not where a prosecutor can hear you if they have to talk about your case and sort of procedural things. And, hey, did you get that alcohol treatment done? Or did you do that DV victim panel I wanted you to do? Hopefully we know about that ahead of time, but you're not going to be talking about substantive things in court. So hopefully your attorney will prepare you for those times when you are going to need to talk. When is it you might need to talk? Well, one might be at the arraignment, the first court date, where you may need to say something along the lines of, whether or not you have a driver's license, what your date of birth is, what your address is, stuff like that. So identifying information. You might have to do some talking at arraignment. Two, you might have to do some talking at the sentencing. When the case is over at sentencing, if unfortunately you have been found guilty of something, let's say a DUI, reduced to negligent driving in the first degree, the judge is going to ask for the prosecutor's recommendation for a sentence. They're going to ask for the defense attorney's recommendation for a sentence, where we're going to talk and say good things about our client. Then they're going to say, Ms. Client, now it's your opportunity to say something. You don't have to say anything, but this is your opportunity if you want to. So in that situation, hopefully your attorney has prepared you for what you might want to say or not say. In the rule of thumb typically is we want to eat dirt and be humble during any type of sentencing. Your Honor, I've learned from this. I really paid attention to my alcohol class, and I learned a lot from the DUI victims panel. I really apologize for my actions. Don't say for wasting the court's time. They don't like that, because it's not a waste of the time. That's where they're there. Apologize for my actions, and I promise to do everything I can to make sure that I never commit any type of crime or any type of situation in the future. Something humble, not making excuses and stuff like that. So you generally, most cases, you're not going to need to say much because it's sort of an agreement between the parties the judge is inclined to follow. But in some cases, it will make a difference. In some cases, we might be asking for a lesser sentence than the prosecutor is. And while we may make a very good argument for you, sometimes, the judge is going to read your energy in deciding, what sentence they're actually going to hand down. So at a sentencing type situation, might be a time where you need to talk. When else might you need to talk? Well, in a review hearing, let's say you've got a probation violation and your attorney may need to ask you on the record about some things you've done or not done. Hey, Mr. Client, it's true that you completed a new alcohol and drug evaluation. Is that right? Yes, it is. And you've already done this treatment? Yes, it is. And here's proof of the treatment. Yes, it is. We can hand it up. Stuff like that. We might need you to establish some things, but hopefully you'll be prepared at that ahead of time. Well, Lance, what about just talking about what happened? When's my chance to say what happened? Well, you're going to tell us, your attorneys, what happened, right? You're going to tell us in private, confidentially, attorney-client privileged, what happened so we can figure out how to best research your case, advise you, settle the case, negotiate the case, or prepare the case for a trial. So you're going to tell your story to us. And finally, the other time when you might get to tell your story is at either a motion hearing or more likely a trial. Let's say you decide to go to trial on that charge of assault in the fourth degree because you've got a bad offer from the prosecutor and we think you have a good defense. Well, once the prosecution puts on their case, then it's our chance to go ahead and present a defense case. And most of the time, we don't want a client to testify because once the client testifies, the jury has a hard time conceptualizing burden of proof. This sort of beyond a reasonable doubt goes out of their heads and just goes, do we believe the defendant or not? But it's your choice as a defendant whether or not to testify. And if you do, you'll get to tell your story to some degree. The defense attorney will ask you questions like, on the day of August 1st, 2022, what were you doing that day, right? We get to ask you some open-ending questions. We don't necessarily get to lead you, but hopefully you'll have practiced with your attorney if you get to that spot. That would be extremely rare. You can count on one hand the number of defendants we've had testify at a trial in the decades I've been doing this type of work. Hopefully we can get a result, and other attorneys can as well. It's a good, positive result without having to risk a trial and risk what the jury thinks happened, because in my opinion, jurors are pretty mad right now. There's a lot of bad stuff going on in the world. They're looking for someone to blame, and it's pretty easy to blame a defendant. So if you have a court date coming up, hopefully this puts your mind at ease. You're probably not going to have to talk about your case if it's a criminal matter. Protection orders, you might have to. But ask your attorney what to expect. Do us a favor and remind us that you don't know what to expect. And, try not to get too mad at us if we sort of take it for granted. But, sometimes it's easy for us experienced people in the system who are more worried about getting the result. Sometimes we forget about what's in our clients' heads if it's stress and anxiety, if they're not willing to share it with us. And if you're willing to share it with us, then we can do something about it. So I always appreciate when my clients let me know that I may be not on the same wavelength as them about how they're feeling. So if you found this useful, I really think it would be great if you like and subscribe because more people get to see it. And more importantly, if you've got a criminal matter in Washington State, feel free to reach out to my firm. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.